be a part of this wonderful program that Roy and others put together, and to be a part of such a distinguished panel. The topic substance and form is really, in this particular panel, is to focus on what's happening in practice. So, at least from a U.S. point of view, we've had some changes. Number one, we've had a codification of the economic substance doctrine in the form of a statutory language under Section 7701, small little o. But having said that, economic substance or substance versus form has been part of our common law, for many, many years. It's very much a fabric of our common law system. There are cases that are quite old, and there are seminal cases that address the criteria for applying substance versus form, and it's applied also in the context of other anti-abuse doctrines like the step transaction doctrine or sham transaction doctrine. But as you can well imagine, today, and having heard from some of the panelists talking about the arm's length standard and base erosion concepts that have been prevailing in jurisdictions all around the world, it's getting just much more attention, and indeed in the United States it's getting a lot of attention in the context of our tax audits. And so I'd like to walk through what's really happened statutorily, why has it happened, and try to interject some experiences that I've had with the application of this doctrine, at least as raised by the Internal Revenue Service on many audits, and indeed audits are the name of the game right now in the United States. There are a couple of elements about the codification of economic substance doctrine. One is, why did it happen? What are the elements now of the economic substance doctrine? And you have some fairly onerous penalties that will apply to the extent that it is applied by a court or the Internal Revenue Service, and it doesn't go forward administratively. The codification took place in March of 2010, and in effect what it did was it adopted a conjunctive analysis of the economic substance doctrine. And by that what I mean is, under the case law, you had three theories of how to apply economic substance. One was a conjunctive test, which looked at both the economic substance and the business purpose of the transaction. So you had to meet both criteria for that to apply. The disjunctive test was basically just the opposite. It said you either, to have substance in form applied, you had to either have a lack of economic substance, or you had to have a lack of business purpose. And then there are circuits, like the infamous Ninth Circuit in California, that really looked at economic substance and business purpose as just mere elements of a hybrid type of an analysis. And I think this graph kind of points out the disparity that was existing over the years in the case law. Indeed, the conjunctive test applied in places like Illinois and the First Circuit up in Massachusetts and in Florida. And then you see the disjunctive test, which was primarily in the Second Circuit, which is New York, and down in Virginia and D.C. in the Fourth Circuit, and then in various states in the Midwest. And then the hybrid approach was applied primarily on the West Coast cases in the Ninth Circuit, which we kind of call La La Land, because whatever they do in the rest of the world, they do differently in California. So depending upon where you were located and where your appeal would be to whatever circuit, particularly if you're in the tax court, the tax court's appeals would go to the circuit in which you would be located. You might get a very different analysis on how to apply substance versus form. So to put some symmetry to the application of the doctrine, there was the codification under Section 7701, and the doctrine basically adopted the conjunctive approach. Now, why did they do this after all these years? Was it simply because they wanted clarity in the law? I don't think so. What you were having was a lot of tax audits where you were looking at the substance of the transactions, and you needed some unanimity in allowing the Internal Revenue Service to be able to attack these transactions. Typical transactions that you might see would be looking at supply chain profit, where you have a low tax jurisdiction, and they're looking to the economic substance